Alright, so we've talked about some of the primary stuff related to litigation, who the parties are, etc. Now, how do you actually start a lawsuit? Well, first thing you do is you file a complaint. A complaint is the document that lays out the complaint that you have. It's done in a certain legal format. It's put together and it's submitted to the proper court that has subject matter and personal jurisdiction. Alright. Once you file a complaint, you serve it on the other party. The other party has generally 30 days to respond to it. And their response is called an answer. Now keep in mind, when they file their answer, they can also file a counterclaim against the initial plaintiff. Okay? So that's what starts a lawsuit, and those are called pleadings. Now once you start the lawsuit, you got to gather information. This is called discovery. Now, the way discovery was explained to me, I'm going to explain it to you the same way, is this, and it's a little ugly, but bear with me. Discovery is going through the other party's underwear drawer. Probably, some of you are probably like, oh, I can't believe he said that. Think about this for a second. Where do you keep your most intimate secrets? You got me? The theory is if both sides know everything there is to know about the matter, then two reasonable, prudent persons would be able to come together and resolve it, come to a settlement. Now, how do you do discovery? Well, what's the purpose of it? Again, the purpose is to find out everything there is to know. You want to make sure that the lawsuit has merit, there's something actually going on. It'll assist you in trial prep, meaning, once you learn what the facts are, you can put those together to see what elements or see what facts support each element of the cause of action, and it also narrows the issues. What issues are we actually going to be talking about at trial? Is there anything that we can actually agree on? And all this is discovered through discovery. Now, how do you do it? Well, generally speaking, the first thing that our office always does is send out interrogatories and requests for production of documents. Interrogatories are questions that are sent to the other side, and the other side is required to answer those under oath. Okay? Request for production of documents is very similar. You ask for specific documents related to the matter. Now keep in mind, whenever you do discovery, just about everything is discoverable. Anything that could possibly lead to admissible evidence in a court of law is discoverable. And you notice it's might lead. Okay? So it's a huge area. Okay? Now, generally speaking, once our office does interrogatories and requests for production of documents, we then look into the possibility of depositions. Depositions is where you actually talk to the various witnesses and the parties, and they're under oath. You ask them questions. It's very similar to what you would do in the courtroom. It's done with a court reporter. Judge is not there. It's just the two attorneys or teams of attorneys, and they go through the process of questioning and answering and whatnot, and you gather information. You can also do requests for admissions, saying, hey, admit or deny these various things. Our office doesn't use those very often, but certainly it is something that's in our toolbox. Scope of discovery. Talked about this briefly, but let me go through it. Discoverable information is allowed if it will lead to evidence admissible during trial. Okay, and again, this is a large area. Now, high cost of discovery. And again, this is where the client spends their money. It's in the discovery process. It's caused by time searching for information, preparing depositions, copying and shipping costs, attorney's fees, interpreting requests. Folks, let me tell you, I'll spend hours working on discovery, just going through documents, reading documents, organizing documents, putting documents together in such a way that it's easy to understand. Okay? Now, certainly with discovery there is room for abuse. Parties can become aggressive and it can damage the litigation process. The key is to act reasonably and prudently and avoid extreme positions. I would make the argument that I'm a very laid-back attorney until you piss me off. I try to work with the other side, the opposing counsel. Try to say, hey, look, I need this, you need this, let's just get the information we need, because it's all discoverable. Now, certainly there are situations where the other party doesn't want to produce something, and you may have to write them a nasty letter, or you may have to do a motion to compel, stuff like that. But the key, in my humble opinion, to discovery is to try to work with the other side, get the information, because the judge is going to say, guys, quit complaining about it, give each other the information. Now, you can also do motions, pre-trial determination of questions of law, statute of limitations. Believe it or not, you have to bring causes of action within a certain period of time. Judgment on the pleadings or summary judgment, meaning, hey, look, judge, we have all the information together, here it is, there's no dispute as to the facts, just tell us what the law is. You can also say it's a frivolous case and try to get it dismissed that way. So you go through the discovery process, you do all your motions, now let's go to trial. You're not able to resolve it, you go to select your jury. The process of selecting a jury is known as voir dire. And certainly both parties question potential jurors, and they can remove a juror for cause, meaning that they're biased, or there's preemptory challenge, meaning that I just don't want this person on the jury. Now, constitutional violations, you cannot discriminate against individuals. So, race, creed, national origin, sex, etc., etc. Now, once you actually get to trial, who has the burden of proof? Generally speaking, the plaintiff is going to have the burden of proof. Okay? They're the party that have to prove their case. The defendant has to play defense. Okay? Now, generally speaking, when you're at trial, it's going to be preponderance of the evidence. Okay? So you got the scales of justice. You just got to tip them in one side or the other. At the criminal level, it's beyond a reasonable doubt. Okay? Here's some more on civil stuff. Preponderance of the evidence is just tipping. Clear and convincing is a little bit more. Okay? And then beyond a reasonable doubt is this. Okay? Civil case decisions, judgments. Certainly, you want a judgment in your favor. Once you get a judgment, you can ask for a judgment notwithstanding the verdict, and that's a post-trial motion. And the judge can enter that to counter the juror's verdict. After trial, you can go through the appeals process and you file a brief saying, hey, this is where the law was inaccurate, where the judge might have made a mistake. You'll go before a panel of three justices and make oral arguments, and then they'll render an opinion. Certainly, once you do all this, how do you enforce a judgment? Well, execution, garnishment. Basically, what I like to do is, if you're suing an insurance company, they have deep pockets. It's usually easy to get your judgment. But if you don't have a situation like that, you may have to garnish the other party. So, like when I do real estate matters, if I'm suing a tenant, I'll get a judgment against them for late rents, unpaid rents, court costs, attorney's fees, yada yada yada. And what I have to do is I have to garnish their wages, meaning I have to send an order over to the employer demanding that they pay X number of dollars out of their check each month to me, so that I can collect on that judgment. So you can see there's several steps that you go through whenever you're talking about trial. It's actually a lot of fun. I thoroughly enjoy going to trial. It is very stressful, but at the same time it is a lot of fun. But then once you go through trial, there are things that you have to do to wind up everything and get matters resolved.